Workers' compensation. Can I receive workers' compensation benefits if I've been fired? Hi, I'm attorney John Sheehan. Since 1993, I've represented thousands of injured workers and car accident victims throughout Massachusetts. Well, first of all, let me answer that question directly. Yes, you can. Yes, you can receive workers' comp benefits even if you've been fired after a work accident. In order to be eligible to receive workers' comp benefits in Massachusetts, the important thing is that you were working as an employee, not an independent contractor, and that you got hurt on the job, that you got hurt at work. And as a result of the accident, you suffered an injury that requires medical treatment and disables you for a period of time. That's it. As long as those things are there, you're entitled to workers' comp benefits, even if later your employer fires you. This might sound odd or strange, but from my perspective as a workers' comp attorney representing injured workers, when my client gets notified that they've been fired, that they've been terminated, or that position was filled, is no longer available, from the standpoint of the workers' comp claim, that's actually a positive thing. It can be a positive thing. Let me explain why. One of the ways that workers' comp insurance companies try to defend cases, try to get injured workers off workers' comp benefits, is if at a certain point in time a doctor, it could be the treating doctor, the injured worker's own doctor, or it could be an impartial doctor, a doctor that's picked by the Department of Industrial Accidents to do an evaluation. So if one of those doctors at some point in the course of the injured worker's treatment says that the injured worker can work but with certain restrictions, and then lists out what the restrictions are. One of the things that the workers' comp insurance company tries to do is to coordinate with the employer to put together a light-duty job offer. It might just be something that exists on paper. It might not actually be real, but it's a way, if they can convince an administrative judge at the Department of Industrial Accidents, it's a way that they can try, the insurance company and the employer together, to convince a judge that there is a light-duty job offer and to terminate the workers' comp benefits. So if the employer has terminated the employment, then they're not able to make a light-duty job offer because they fired the employee, they fired the injured worker. If fired, the employer and the insurance company can't play that light-duty job offer game. And as a result, it oftentimes, in my experience, makes it easier to be able to settle the workers' comp case. In most cases, in my experience, that involves serious injuries and long disability following a work accident in Massachusetts, most injured workers don't want to go back to that job, either because they know that they can't do it and they're afraid of getting re-injured, or they're afraid of retaliation. They're afraid that if they go back, the employer will look for an excuse to fire them anyways. If you'd like to talk with me about your workers' comp case, if you've been hurt at work in Massachusetts and receiving workers' comp, or if you've been hurt at work in Massachusetts and your workers' comp benefits have been denied or terminated, feel free to call or text me at the number below. And if you'd like to see my future videos, please subscribe to my YouTube channel.